Prashasti,
Yes, sir.
I think we should adhere to the time. Okay.
Okay, sir. Yes, sir.
Now it is 4 and 1. Okay.
Yes, sir.
Without
So,
waiting for the others, I think we should start. Is it okay, Arvind sir?
Yes, 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 sir. Yes, sir.
Student will join.
Yes, yes, yes. Sure, sir. Sure, sir. Sure.
Yes. Please start, Prashasti.
Yes, sir.
yes, sir. Good afternoon, one and all present here. I, Prashasti Srivastav, on behalf of Manikchand Pahade Law College, welcome you all in a second day of our one-week online lecture series on jurisprudence, with the tagline of "Program of the students, by the students, and for the students." Now, moving ahead, I would like to take an opportunity to briefly introduce our resource person of today's session, Dr. Arvindranath Tripathi, sir, who will be addressing the topic A Conspectus of Jurisprudence. Respected sir is a research assistant at DSNLU Vishakhapatnam. Sir has completed his BA LLB from University of Kalyani, Kolkata, and LLM from Dr. Ram Manohar Lohia, National Law University, Lucknow. Sir has done his PhD in law on the topic Witness Protection Law and its Efficiency. Sir has more than 20 international publications to his credit. Sir has participated and presented papers in various national and international conferences, seminars, and workshops. Sir has also worked as law clerk trainee at Allahabad High Court bench at Lucknow. Sir has areas of interest are jurisprudence, international criminal law, land laws, media law, and constitutional law. So we are honored to have you today with us. Now, before proceeding towards the session, there are few instructions for the attendees. Kindly mute your audio and video so it could not create any hindrance in the middle of the session. If you have any questions, put it in the chat box or the comment box. It will be taken up by the sir later. Now, I kindly request Dr. Arvindranath Tripathi sir to take over the charge. Over to you, sir.
Thank you, Prasasti, for giving the brief introductions. And I would like to thanks first of all the MP Law College authorities, especially to Professor Dr. C.M. Rao sir for giving me this opportunity to express my views and the thought with respect to the area of jurisprudence. Okay, and today my PPT is visible, no issue.
Yes, sir. Yes, sir.
Okay, thank you very much.
Yes, sir.
So today I'm going to deal with the very specific topic that is called the topic of conspectus of jurisprudence. Okay, basically the conspectus of jurisprudence in our lecture I'm going to discuss about that what is the basic structure. Okay, what is the what is the what is the main aim and object of reading and understanding the jurisprudence. Okay, basically we try to understand that what is the basic aim and object, or you can say the basic objective behind reading these kind of law. Okay, so in a very structured manner we will first of all I'd like to try to focus about. First of all, I'd like to try to about focusing about the basic overview of the jurisprudence. Okay. Secondly, I try to try to discuss about the various perspective of jurisprudence. Okay, because various school of jurisprudence they try to analyze the jurisprudence from their own thought structure, from their own perspective. So I would like to try to focus certain areas, not all, but certain areas of the perspective behind the jurisprudence. Okay, and also I would like to try to focus about the utility or the aim and object of reading these law. Okay, jurisprudence, why we are reading this law, what is the utility, what is the aim and object. So we try to focus that area also during our lecture. Okay, and we also try to focus one of the very main area, that is called the relationship between the law as well as with other social sciences. Okay, how the all the social science subjects are interconnected with the law. Okay, and we try to also focus about what are the various concerns of the jurisprudence, what are the various topic or the subject matter which is dealt with by the jurisprudence. Okay, so let us start one by one in a systematic manner. First of all, okay, the jurisprudence. What is the meaning of jurisprudence? Jurisprudence is nothing but it is originated from one Latin word that is called jurisprudentia, which means juris means the law and prudence means the knowledge of law. Okay, so basically the jurisprudence is nothing but it is a knowledge of law. Okay, and if you ask me that specifically that what is the exact or the uniform definition of the subject of jurisprudence, then in that case I will say that no, we don't have any uniform structured single definition of jurisprudence. Okay, the jurisprudence has been defined by various authors, various jurists, various writers from their own perspective, from their own point of view. Okay, and at the same time, uh, these you must have to understand that these jurisprudence is not at all, it is not at all a law subject. Okay, it is telling about the law. Okay, it is not a law, but it is telling something about the law. So we have to must focus, or we have to know one basic thing when we are reading jurisprudence. Then we have to understand that we are not analyzing or understanding any specific statutes, rules, regulations, or the bylaws. Okay, because generally when we are reading CRPC, IPC, CPC, in that case we are reading certain structured rules, regulations. Okay, we have certain sections, we have certain explanations, we have to apply the sections, articles, and we will get the meaning of the particular law or the piece of law. And sometimes we are also applying the case law, and that is the basic structure of the structured law. But here in the jurisprudence, we are not try to, we are not learning only that structured or the statutes laws, but here we try to understand and try to read the various general principle of law. Okay, general concept of law, as well as various philosophical thought structures, perceptions about the law. Okay, we try to focus all these area, like what is the meaning of complete justice, whether we have any specific meaning, because as you know that article 142 of Indian constitution laid down, given or empowered the honorable Supreme Court of India that they can pass any order or the direction for doing complete justice. So we have to understand that what is the meaning of complete justice, whether this complete justice has been defined or given any exhaustive meaning in any statutes or the constitution. No, not at all. Okay, so how to gather, how to get the true or the real meaning of these kind of complex concepts, complex principles? So that is the answer you can find out in the jurisprudence. If you are very good in jurisprudence, you can play with the technicalities of law. Okay, you can make an argument for and against both the things, because jurisprudence given this it give you the thought structure or the critical analysis idea. Okay, so this is the one of the best subject which you can understand. This is providing you the basis upon which all the legal thing is based. So so please try to go through this subject in a very detailed manner, and I will make sure that this subject is not at all giving certain concept ideas, but at the same time, these subject provide you the basic backbone, or it increase the confidence upon in with respect to any legal student, even the lawyers, even the judges. Okay, so these provide you the basis. Okay, how, what is the genesis of law? Okay, what is the utility of law? Whether, what is the meaning of just unjust law? whether what is the various concept of law, what is the meaning of ownership, positions, right, duty. So all these complex concept has to be deal or read or understood in these subject of jurisprudence. Okay, what is the meaning of, what is the variety categories of justice? Okay, what is the difference between the law and morality? All this has to be deal, all this is, it has to be discussed in the concept of, in the study of jurisprudence. Okay, it is nothing but it is a searching of the black cat in the dark room, which is very difficult but not impossible also. Okay, so this is the thing, this is the overview of the jurisprudence. And at the same time you have to understand that in the jurisprudence it has certain universal feature. Okay, the principles are universal in nature. Okay, for example, the principle of natural justice. Okay, so these principles, these meaning of ownership, positions, all these concept of jurisprudence, all this school of jurisprudence, whether natural school or analytical school or sociology school, all these has to be, it has certain uniform nature. Okay, whether if you go to the Harvard, Cambridge, in any throughout the globe, you will read the same kind of principle application and the concept of jurisprudence. But the difference is only that the applicability of these jurisprudential concept or the principle differ from country to country or the nation to nations. Okay, to a certain extent. So this is all about the basic concept of jurisprudence. Okay, and at the same time it developed the critical analytical mind with respect to the uh, any subject matter. Okay, with whether the law or the non-law, it developed the thought structure process. Okay, I, I already discussed that definition of jurisprudence have many writers, many authors, many jurists, they define the jurisprudence from their own thought structure. Okay, like for example, Austin, according to the Austin, the law, the jurisprudence is nothing but it is a philosophy of positive law. He claims he is claiming that the law is nothing but it is a command of sovereign which is backed by sanction. Okay, so he's a positivist. He's an analytical thought structure or the supporter of the school of jurisprudence, and he is saying that whatever the law as it is, it has to be followed. Okay, if it is flow from the proper appropriate authorities. Okay, and it has the certain basic feature, if it fulfill in that case, it become the law. And the Austin, as because he's dealing with the positive law school, in that case he's not dealing with the goodness or the badness of law. He is saying that okay, if it is a command, we have to follow it. There is no connection between the law and morality with respect to their positive law school. Okay, he's talking about something law as it is. Okay, according to Levinon. Okay, in this case, he's an analytical law school. He's a realistic law school philosopher or the jurist, and he's saying that law is nothing but it is the empirical study of event and fact which influence the judge. Okay, and according to his thought structure, the jurisprudence is nothing but it is a structural structural learning of the process of the outcome of the from the judiciary, or what the judges are deciding. That is the actual law. Okay, whatever the law is there in the books or the textbook, that is not at all very much relevant. Some relevancy is there, but the major relevancy is upon the outcome of the particular decision of from the court or from the decision. That is the basic uh, basic background of jurisprudence. Okay, and so and the another jurist that is called Ulpin. Okay, he is also saying that jurisprudence is nothing but it is the observation of the things human and divine, the knowledge of just and just unjust. Okay, these jurisprudence is nothing but it is dealing with the certain just and unjust matter. Okay, so we can find the different varieties of the jurists who are discussing, who are defining the jurisprudence from their own thought structure, from their own perspective. But we cannot say in the jurisprudence that Austin is right or the Bentham is wrong, or the Bentham is wrong or Levin is right. We cannot say like that, okay? They all are jurists, they all are philosophers, they have all the freedom to interpret or to perceive the basic philosophy of law, okay? So in the jurisprudence, we can criticize every time and any time, okay? Because I may not agree with the Austin, you may agree with the naturalist. So different varieties of inter-conflict statements are there even in the jurisprudence, okay? Somebody is saying that there is no only the law is command. Somebody is saying no, law is not a command, it is a natural thing which is coming from nature itself. So many things are there, okay? And here in the jurisprudence we are not try to understand or try to read the basic the basic uh, the basic law, okay? Because in a basic law we are saying that this is the statute, this is the law, but here we try to analyze, understand, or interpret the law in a very holistic manner, okay? Or we can say we try to analyze the law in a very abstract manner, okay? For the jurists, they are saying we have also natural law, okay? We are not only the written laws, we have also natural law. So in that case lot of conflict is there, but anyhow the outcome is remain the same for the welfare of the society, for the development of the human being, that for that the law is there, okay? So let us understand, try to look after that, what is the basic use of jurisprudence, why we are reading these subjects. The first thing is very much important, that it provide you or it give you the basic nature of law, okay? What is the nature of law? That is also to be very much important for everyone, because whether the law is there for the welfare of the society or for the welfare of the individual or for enjoying their own life, what is the basic nature of law, okay? Whether the nature of the law is to uplift the morality or for individual progress, okay? So what is the basic nature of law? And if some conflict is there between the law and morality, then in that case which has to be prevail, whether the morality will prevail or the law will prevail. So we don't have exact appropriate answer with respect to all these questions, so it depend upon person to persons, okay? For example, I will give you one very basic example, okay? Like Justice, Honorable Justice D.Y. Chandrachud, okay? He passed an judgment of struck down section 377 of the IPC. What does it mean? He is recognizing the LGBT right, and he's talking about constitutional morality. What is the meaning of constitutional morality? Okay, he's not talking about individual morality. He's talking about that constitutional morality must be upheld. Okay, and the LGBT should not be criminalized just because we have positive law, or we have the section in the IPC that is called section 377. We cannot penalize them just because they have different sexual orientations, okay? We have the law is there, okay? For the general man, for the general understanding, that is the law. But when it come to the highest interpretation of the law by the Honorable Supreme Court of India, then in order to impart complete justice, which is the motto of, or you can say, which is a pious duty of Honorable Supreme Court of India, to provide or to do complete justice. For doing that, they stuck down these provisions and they recognize the basic human rights of LGBT. Okay, because we have to forget what is the law. It is the basic nature of law to enjoy their life. How you, by making certain law, how you can debar the particular section of the society to enjoy their freedom, enjoy their right? Okay, So that is a nothing but this is a concerned matter of the subject matter of the natural law. Okay, so this is a natural law which we cannot stop by 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 the positive law. Okay, because IPC is nothing but it is a classical example of positive law. You can't punish anyone because it is in contradictory to the even the natural law also and even the constitutional morality also. So all these toughest concept is there, all these you can say the conflicting opinion thought structure is there which we have to respect. Okay, just see, we have the law at that point of time also, but nobody come forward to make recognize such kind of right. What is the reason? Because it depend upon various things, upon the mindset thought structure of the judges also, sometimes their upbringing, their their educational qualifications, their professional personal background, all these has certain impact upon the quality of judgment also. And this is nothing but this is also showing the realistic school of jurisprudence. Okay, so all these complex matter has to be dealt with the subject that is called jurisprudence. Okay, the second thing is for for tracing the underlying principle of jurisprudence or the principle of law. Here we have various principle of law, various basic principle of law, like the principle of natural justice. We are aware about the fact that we have two principles of natural justice, that is called audiotum partem and nemo jurisdictum causa sua. And both principles are nothing but this is the part and parcel of uh, uh, the legal system, not only in India but throughout the globe. Okay, and everyone has to follow these basic principles of natural justice. But if you ask me that what is the exact definition of or what is the exact extent of the applicability of the principle of natural justice, in that case I will say no, it depends upon the fact and circumstances, or you can say we don't have the exact state cut formula or the definition of the principle of natural justice, but generally we are saying that these two principles are there. Okay, and in the Menka Gandhi case versus Union of India, the Honorable Supreme Court held that uh, that nobody can deprive from his basic fundamental right except the procedure established by the law, and the process must be just, fair, and reasonable. Okay, just because you are enacting certain rules or regulations and by the mechanism of law you can't debar any person from their basic fundamental right. Okay, and the process must be just, fair, and reasonable. Okay, and this is nothing but this is the progressive attitude and or the approach of on the Supreme Court of India pertaining to upholding the principle of natural justice. Okay, and the third use of the jurisprudence is that it helps us the development of the critical faculties or the legal perceptions of our mind. Okay, whenever we have the thorough knowledge of these subject of law, or that is called jurisprudence, in that case it developed the thought structure process, it modified, or you can say it mold your whole process of thinking process so far the law is concerned. Okay, in the basic level, or you can say in the ground level, we are saying that this is the law, this is the rules, this is the regulation. But when we go to the higher level, when we start criticizing, commenting, debating, discussing, in that case we can come across to a various subject matter which develop your thought structure process, and these subject of jurisprudence help to stimulate to critically think all these legal perceptions of law, all these various legal principles or legal philosophy in a very sometimes scientific manner, sometimes in an abstract manner. Okay, and these also help us to understand the true meaning or the perspective of law. Okay, it also help us to understand that what is the linking, or what is the what is the relationship between the other social sciences, like what is the relationship with sociology, political science, economics. Okay, so what is the relationship with all the other subject with law? So if these subjects give you certain pinpoint or certain light upon all these interdisciplinary mechanism or holistic approach to reading and understanding or interpretation of the law. Because after all, we know that the law has to operate within a given society. Okay, and it cannot be read or implement or executed in a isolation. So we required society, we required a certain people to follow it. So all this has to be understood when we are reading the jurisprudence. Okay, because ultimately if you go through our Indian constitution also, then the preamble of Indian constitution also itself reflect about the basic ideology of imparting justice not in a legal manner or in a legal justice. They are talking about justice, social, economical, political justice. So all these subject has certain uh, uh, this close relationship between to understanding or to appreciate when we are appreciating the various theories of law. Okay, and the lastly but not least, that it help us to the jurisprudence help us to understand various technical legal terminology. Okay, various legal concepts are there, like what is the meaning of ownership, what is the meaning of positions, what is the meaning of uh, constructive positions or actual positions, what is the meaning of right and duties, what is the relationship between the right, duties, immunities. All these complexities has to be understood in these subject. Okay, and not only these, but sometimes it may happen that we are not able to get the true meaning, the true interpretation from the statutes, from the constitution. In that case, we cannot as a judge the judge cannot say that we don't have any rules, regulations, case laws, we are not going to deal with this subject matter. They can't escape, even the advocate can't escape to handle such kind of cases when the law is absent, when the law is not there, when the law is gray, there is a gray area or the case law is not there. In that case also, these subject matter of jurisprudence help to overcome from such area. Okay, it provide you the it is a considered as a eye, it is a considered as a backbone, it is considered as a science of law. Okay, so many thing many things is there. Okay, with respect to these things, even if you ask me that what is the basic philosophy behind international criminal law, so many of you think that international criminal law is nothing but it is a positive law, but no, not at all. If you go to read some of the Oxford, Harvard law review journal, in that case they are categorically laid down that no, the the there is a philosophical background of these international criminal law, and the uh, Bentham is one of the best jurists who is making a lot of contributions with respect to the development of these uh, philosophy or this branch of law that is called international criminal law. So this is the things. So after that, I would like to try to discuss about that. We have various school of jurisprudence, like analytical school of jurisprudence. Basically, analytical school of jurisprudence is it is also called as a positive law school, or you can say a Australian concept or Australian law school. And this is nothing but this analytical law school or the positive law school. It is dealing with the law as it is. Okay, and they are saying that law is nothing but it is a uh, command of sovereign which is backed by a sanction. Okay, and they are saying that law as it is. Okay, and they are also try to focus upon the fact that there is nothing to there is nothing with relation to with the morality. Okay, so these even we have uh, merits as well as demerits with respect to these analytical school of jurisprudence. Okay, so you can read by these things. Okay, various persons are various jurists are there, like Austin, Bentham. All these fall within the category of analytical school of jurisprudence. Okay, the second is that is called sociological school of jurisprudence. Under this sociological school of jurisprudence, it deal with the basic operation of the of the legal law. Okay, and they are saying that law is nothing but it is depend upon the outcome. Okay, how it affect the society. That is the main concern of the jurisprudence or the legal system. Okay, and they also focus about the concept of maximum you can say the Roscoe Pond come with a theory that is called social engineering theory. Okay, with the minimum frictions we have to achieve the maximum welfare of the society. Okay, and that is the thought structure of these kind of sociological school of jurisprudence. Okay, like Durgitz is there, and Roscoe Pond. So many jurists are there which is advocating these school of jurisprudence. Okay, and here the the main area or the major focus is upon the society. And in another school of thought, that is analytical school of thought, the state is a focus point. Okay, and the third category of the school is realistic school of jurisprudence. Okay, and this is also very interesting school of jurisprudence where the the various jurists they they emphasis upon the fact that law is nothing but it is a byproduct or outcome, or you can say it is, the real nature of the law is upon its outcome which is delivered or which come from the court. Okay, what is the real outcome? That is the exactly the law. It is not the exactly the law is not in the textbook or the in the sections or in the articles, but the real outcome from the court, that is the real that is a real law. Okay, and in the realistic school of jurisprudence, sometimes they are focusing more upon the individualistic characteristic of judges. Okay, and they are saying that 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 judgment is differ from person to person. Okay, suppose if the fact and the circumstances of the case is same, but my observations, my outcome, my decision may differ from your decision, and it depend upon various factors. Okay, so various other factors also play a very important and significant role with respect to the outcome of the decision. Okay, my background, my personal or my personal or professional um, uh, professional stage, or you can say that what is my economical status, my social status, my educational background, all these had certain impact upon the my outcome or my decision. So they are concerned about all these aspects. Okay, in the economical and economical school of thought, the various jurists, like even the philosopher like Marxism, they are saying that we have the close connection between the economics and the law, because ultimately we have to impart the economical justice too. So that is the thing. Even the historical school of jurisprudence, under the historical school of jurisprudence, it trace out, it provide you the basic background of the the systematic development of our legal system. Okay, whether the law is gradually or suddenly originated. Okay, what is the basic nature of law, whether the law differ from one society to another society. Okay, so various historians, they lay down or they make an emphasis with respect to these school of jurisprudence. Okay, and lastly, that is called the natural school of jurisprudence. Okay, and these natural school of jurisprudence, and they are focusing about the basic fact that that uh, that uh, that law is not at all given by the state, but it is a divine law. It is a natural law which is inherent, okay, which cannot be taken away, okay. And like the principle of reasoning, or you can say the principle of natural justice, okay, certain basic principles are there, like the force of gravitational force. This is the law of nature. It can't be changed, it can't be set aside. So certain inherent natural law is there, okay. And even nowadays also we are following all these school of thoughts till date also. So this is the basic structure of the various school of jurisprudence, okay. And the various school of jurisprudence is nothing but it it provide you the platform where some categories who have the same mindset we can categorize, and we are going to read in a very systematically approach, or in a by very systematic method, by putting their views in that school of thought, okay. But please don't get confused that these all the school, whether analytical school, sociological school, natural law school, historical law school, or realistic law school, or economical school of law is 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 isolated. It has to be sometime overlapping with each other, and we are dividing these school of jurisprudence just for our better understanding, or better appreciating these subject of jurisprudence, okay. And you may ask me that uh, whether any systematic approach of reading these school of thought. First school of thought, we have to start with which school of thought, whether it's natural school or historical school. We don't have exact answer with respect to these things, okay. In the various books you can find out different structural things, okay. Somebody many writers, jurists, they start with the natural law school. Many economic many jurists, they start with the historical school. So we don't have any structure mechanisms, okay. So this is a brief introductions, and whatever I discuss now with respect to the various thought structure or various perceptions of jurisprudence, or various with respect to the perception of law from all these school of jurisprudence, they differ from each other. But we cannot say that one is good or one is bad. Okay, it has its own relevancy. Okay, and the best thing which we are learning in jurisprudence, that when we have to apply which school, okay, whether right now whether we have to apply in a particular given fact and circumstances the natural law school or the sociological school, or analytical school, law school, which school has to be applied at which circumstances or which given point of time, that is the again the subject matter of um, a perception that we have to understand, okay. And that is the even the duty of Honorable Supreme Court of India, that is the basic discretionary power which is given to the Honorable Supreme Court of India to provide complete justice by the virtue of Article 142 of Indian Constitutions. And while doing so, while imparting complete justice, they can adapt any school of jurisprudence, okay. And these kind of philosophy, these kind of critical thought structure provide you the platform, or you can say the backbone, to justify your thought structure. That is also true, okay. For example, I can criticize anything, whether it's good, bad, it does not matter at all, okay. We can criticize, and these school of jurisprudence, all these school of jurisprudence give you these stimulation exercise, these develop these critical faculties of the mind, okay. For example, so we can give cite so many examples, okay. So so let us understand that what is the meaning of, what is the basic concept of jurisprudence. The jurisprudence concerned about what is the law, okay. What is the law means does not means in a surface level, but we try to understand and analyze the law in a very abstract manner, okay. That what is the main purpose, motive, intention, or aim and object of the law, okay. The second thing is what is the source of law? Whether the precedent, whether the legislation, whether the custom is a source of law or not. And if the precedent or if the custom is can be recognized as a source of law, then what are the essential element which has to be satisfied by this custom to become accepted as a law? So whether under what circumstances the precedent can be uh, set aside, okay, whether the precedent can be followed in every circumstances in all the case or not, all this has to be deal with the subject of jurisprudence. It also deals with the concept of laws, okay. The concept of law means here that during the course of reading the law we come across several words like rule of law, niti, nyay, justice. What is the meaning? What is the scope, nature of these all laws? What is the basic element which has to be fulfilled in order to become ownership, positions? Okay, so it has to be understood. Okay, what is the relationship between all these structural things of immunities, liabilities, these duties, rights? So it has to be understood, and these platform, these jurisprudence provide you these background. Okay, the jurisprudence is also concerned about the subject matter of ideal law. Okay, what the jurisprudence is not at all when you're dealing with the law as it is. Okay, because we know we are aware about a particular fact that what is the present law, but the jurisprudence is also try to analyze, try to deal with the subject matter of what the law is to be. Okay, and how these system of justice can be achieved. So all these are the concern of the jurisprudence. So if I will not discuss something about the concept of dharma in the context of jurisprudence, then I think that I am doing something, some injustice. So because the concept of dharma is a basis of the legal system in India. Okay, and basically you know that Manu, we have so many things like Manusmriti, Manushruti, Shruti, and all these Dharma Shastras are there where it give you the basic concept or the rule pertaining to governance of the society, the individual conduct, how to, what is the meaning of Raja Dharma, all these things is discussed in a very elaborate manner. Okay, the Dharma is representing the ideas or the thought structure for the social harmony. Okay, it laid down the basic relationship between the law and morality. So all these concept is the concept of dharma, and this is the basis of our Indian jurisprudence. Because whenever we are trying to focus about the subject matter of jurisprudence, in that case we try to not generally but always we are focusing about Western jurisprudence. We always take the name of Austin, Bentham, and all these Western Jews. No doubt, we have to just we are not neglecting their contribution, but at the same time we should must understand the contribution of from the Indian legal communities, from the legal from the concept of dharma. Okay, because I would like to make a distinction, okay, between two things, that administration of justice and the dharma. Okay, dharma is representing our own legal Indian legal jurisprudence, where we are having certain self regulations, no third party is there. With respect to the dharma, we believe in the concept of punya and pap. Okay, we believe in the concept of niti and nyay. Okay, we believe in the concept of these kind of niti and nyaya, and this concept is not at all in a very abstract manner. This is systematically laid down in various textbooks, and and it is self-regulation mechanisms. Okay, we, since from the birth we are learning these things. This has become the part and parcel of our life. Okay, the concept of punya and pap, and here it is self-regulations. Okay, killing of the human being. It is since from our birth we are learning this habit. Okay, and the concept, the administration of justice, which is a Western concept, it is here it is administrated by third person, that is called judges. But here in the Indian concept, we are self-regulations. Okay, our concept of jurisprudence is much more higher, and sometimes we are saying that the concept of natural justice. Okay, and we are giving very they like the Latin maxim that is called the principle of audium partem, nemo juris non sua. It is nothing. It is a Western concept. Okay, it is. But since generations in India, uh, we are giving the nyaya with yukti, which means that the the justice has been delivered by the even the kings, by in the ancient age also, by giving yukti. Yukti means the reasoned decision. The decision should always be reasoned decisions. Okay, so all these things are there in our Indian legal systems. Okay, so I would like to complete or conclude my discussions with respect to the conspectus of jurisprudence with one case, we can say one example. Okay, that is called the dilemma of the child. Okay, here the dilemma of the child, here there is one boy who had fair hair. Okay, and he, when he returned from his school, then he expressed his father that, father, today the headmaster make a new law or the new rules, and according to the new rules, the headmaster of the school, they say that the person or the child, the children who have the fair hair, they will only get the arithmetic lesson, and the other person who don't have, and other persons may not have, they don't have the exactly the lesson from that thing. Okay, so in that case, the headmaster make a discriminations with respect to teaching methodology or teaching, providing the lesson on the basis of their fair skin. Okay, and the same thing is expressed by the child to his father. Okay, and the child is very much depressed. He's saying that he's making a critical analysis of the headmaster, and he's saying that how the headmaster can make such kind of rule that the child who have the fair hair, they don't have to come to the class, and they have to work for the some other work like the wood work. So how the headmaster can make such kind of rules, different rules, on the basis of the color of the hair skin, hair? So that is he is very much upset, and he's saying that it is very much unfortunate. But the father is saying that, but at the same time, you have to follow his decisions, because ultimately the principal of the school, he is the headmaster, and he is the authority to make the rule. So do you think that the child will go beyond the letter and the spirit of the law which is made by the headmaster? No doubt here the headmaster make a certain unjust, unfair law, the rules. But whether the father is asking whether you will go beyond the letter and the spirit of the law which is made by the headmaster, because he is there to make the law. So the dilemma of the child is that who is right and who is wrong here? Here, if you go to the classical, if you go to study, means if you go emphasis upon the school of various school of jurisprudence, then in that case, the child represent the the natural school of jurisprudence. Okay, and the father, he is advocating the positive law school of jurisprudence, Father is saying that whatever the law is made, you have to follow it. Where you don't have to go to analyze the goodness or the badness of law. But the child, he is saying about the natural instinct. He is saying that how the law can be made in such a circumstances when the law is unjust, unfair, unreasonable. Okay, he can't make such kind of rule. So in this manner, that this is the dilemma, and this is not the dilemma in a theoretical manner, but this kind of dilemma happen and occur many times even in our life. I mean, even in when we are interpreting, when we are reading these cases, as well as in the real circumstances also, we come across several times this kind of dilemma, and this kind of dilemma is best resolved only by the virtue of best interpretation or best understanding of by by the subject of jurisprudence. Okay, so this is the subject matter, or this is the thing which I would like to focus. Okay, if you have any question, you can ask me. Hello. Yes, sir.
Prashasti, Dr. Chavan sir, yes,
Yes, sir.
should we open this for question and answer?
Yes.
Because we have 8 minutes with us now.
Yes, yes, sir.
Okay. 1 minute, sir. Sir, there is one question.
Yes, sir.
What is the basic difference between the Smritis and Sutras?
Srimiti's and sutras.
Hmm.
Even I don't have the detailed understanding right now. Okay, I will come with the preparation, then only I can set all these things, because right now I'm not well prepared with respect to making distinction between all these things. Okay, just my today my scope of the lecture is just confined with respect to the its conspectus of jurisprudence, which means that I wanted to summarize the whole structure of jurisprudence. Okay, and today my focus is to give you the basic ideology or the thought structure, how to study the law. Okay, what is the background, what are the merits, what are the demerits, what are the limitation of and how to perceive the jurisprudence. Okay, but at the same time, I would like to also focus the things like that we should come forward to understand, to read these kind of either the Srimiti's, Shrutis, okay, and all these things in a detailed manner, because this is our limitations. Okay, as a jurisprudence faculties, we are not very much very much trained in that manner to read even the concept of dharma. Okay, so we should come forward to read, to understand these concept of dharma. Okay, I'm also trying my level best to try to read and understand these concept of uh, these various concept of dharma. Okay, but we are very much focused about these western thought structures of the process, because what is happening, do you know that that sometimes we don't have the uniform structural mechanisms to read or to appreciate such kind of law. Okay, the the jurisprudence basically is nothing but it is a giving you the lenses, or you can say it provide you the various background by the virtue of which we can develop our critical structure or the process of our mind. Okay, it help us to understand and appreciate the law into its new perspective. Okay, because the law is there. Okay, but how to read the law, how to make the how to interpret the law in the best manner, so that it can be used or it can be provide the better satisfaction of the larger people, okay. And sometimes we are concerned about these concept of idea of justice, okay, because ultimately the goal of our whole jurisprudence is to provide is to concern with the outcome of justice, okay. And the niti is not always sufficient, okay. We have the rules regulations, okay, but at the same time we should must have to understand that how these how these justice can be achieved, okay. Even we don't have the concise definition of the justice also, okay. It vary from person to person or jurist to jurist, okay. Somebody is saying that it is a distributive justice, somebody is saying that when we are giving the equal opportunity to everyone, then that is we are able to provide justice, okay. And many philosophers, many thinkers that define justice from their own perceptions, from their own context, okay. uh, Once you please go through the book that is called The Idea of Justice, okay, which is written by Professor Amit Sen, okay, and he's talking about the concept of the niti and nyaya, okay. And he's talking about that niti is the surface level where we wanted to achieve the ultimate target of nyaya, okay. The nyaya, which is the true, or you can say that it is a complete justice, okay, which is also the motive of the Indian judiciary to achieve, okay. So all these things has to be understood and to read in a new perspective, okay. For example, uh, like uh, we are focusing about these LGBT right. In these LGBT right, we cannot say that we cannot dilute the individual right on the name of morality, okay. Here the natural laws could come into picture. We cannot say that we have the custom, we have the moral standard, we cannot recognize these LGBT right on the name of certain customary practices or morality, okay. We can't do all these things. We have to recognize even supramalai judgment, okay. What is that? We have to we should come forward for achieving the gender justice, and we cannot achieve the gender justice until unless we can give the equal right to the male and female, okay. Again we may have criticism, again we may have a counter argument, okay, that we cannot dilute these customary practices, but at the same time it different, it vary from person to person, from fact to fact, from circumstances to circumstances. And again we have to understand and we have to know one basic thing, that what is right, what is right today may be wrong tomorrow, or what is wrong today may be right tomorrow, okay. So it vary depend upon fact and circumstances of the given case, okay. And these subject of jurisprudence provided you the best mechanism or the methodology. It provides you the complete methodology that how to analyze the law, how to analyze the various concept of law, okay, how to make a critical analysis of all the subject, okay, and how to read, how to analyze the various subject of law, okay.
Thank you so much, sir. So there is one more question that what is the basic concept of jurisprudence?
Basic concept of jurisprudence, okay. So throughout the 1 hour, we are dealing with the same concept of jurisprudence. That is called the conspectus of jurisprudence. Okay, we cannot give you the exact definition of jurisprudence. Okay, but the jurisprudence, the definition of the jurisprudence is vary from one person to one jurist, and at the same time, the whole jurisprudence dealing with three things. Okay, it 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 try to define you the basic nature of the law, it try to provide you the basic concept of law, Okay, what is the various concept like ownership, positions, all these concept is analyzed and try to read these concept, ownership, positions, right, duties in the context of jurisprudence. Okay, it provide you uh, the knowledge about all these structured things. Okay, and at the same time it provide you the basic background of tracing the law. What is its importance? What is its applicability of law? How to balance the concept of various conflicting interests? All these has to be understood. It provides you the basic backbone of analysis of the law. It provides you, it develop the critical analysis or understanding of law. Am I right? So we don't have any exact specific answer. That is a reason we sometimes try to understand and read these law in a very abstract manner. Okay, we don't have to go to the systematic approach. Even just see in my lecture, I'm not going in a very systematic approach. Okay, because ultimately our target is to achieve justice. Okay, we have to understand. Okay, and for achieving these target we have various mechanisms, we have various process, but ultimately we have to come to the same point, that is achieving these complete justice. Okay,
Thank you so much, sir.
thank you very
On
much.
the behalf of the entire fraternity of Manikchand Pahade Law College, first of all, I extend my deepest sense of gratitude to our resource person of today's session, Dr. Arvindnath Tripathi, sir, for making this session a worth listening with his presence and knowledge. I extend my sincere thanks to our respected principal, Dr. C.M. Ross, sir, Vice Principal, Professor Shri More, sir, Faculty in charge, Dr. Amal Chauhan, sir, and IQAC Coordinator, Dr. Aparna Kotapalle, ma'am, for their unflinching support and coordination. Last but not the least, I thank all the attendees on Zoom and YouTube for their valuable presence. Before ending this session, I request to all the attendees to remain present tomorrow at the same time, where Dr. Naresh Wagmare, sir, professor in Department of Law at Savitribai Phule Pune University, will be dealing the topic of sociological jurisprudence. Till then, stay tuned, stay safe. Thank you all.
Thank you, sir. Thank you very much. Thank you very much.
Thank you, sir.
Thank you very much.
Thank you, sir.